DOLS was introduced in 2009 to provide legal authority to care for people in care homes and hospitals who lacked the mental capacity to consent to their arrangements and were under high levels of care and supervision, prompting an assessment to recommend an authorization for the person to be deprived of their liberty with the necessary safeguards applied. DOLS has been criticized for being overly complicated and bureaucratic. Furthermore, following a case which went to the Supreme Court in 2014, the Cheshire West case, the number of referrals increased dramatically due to the reduced threshold for identifying a deprivation of liberty. This combination of excessive bureaucracy and the increasing number of referrals led to criticism that the DOLS was no longer fit for purpose. The UK government asked the Law Commission to undertake a review of the DOLS scheme following a critical report from the House of Lords in 2014. The Law Commission's report concluded that DOLS are overly technical and legalised, are not meaningful for disabled people and their families or carers, fail to secure buy-in from health and social care practitioners. The Law Commission commented that the rights of people who are deprived of liberty and those supporting them are difficult to discern. The UK government passed the Mental Capacity Amendment Act 2019, which extends to England and Wales to replace DOLS with LPS. Some things will stay the same, some elements are reinforced, and some will change. The UK government's intention is that LPS deliver the following changes: create a new simplified legal framework that is accessible and clear to all affected parties, deliver improved outcomes for persons deprived of their liberty and their family unpaid carers, provide a simplified authorization process capable of operating effectively in all settings, ensure that the Mental Capacity Act works as intended by placing the person at the heart of decision-making and is compliant with Articles 5 and 8 of the European Convention on Human Rights. Provide a comprehensive, proportionate and lawful mechanism by which deprivations of liberty for young people aged 16 and 17 can be authorised. Ensure increased compliance with the law, improve care and treatment for people lacking mental capacity, and provide a system of authorisation in a cost-effective manner. What is deprivation of liberty? The definition of deprivation of liberty is based on past judgments made by the European Court of Human Rights. It is directly linked to Article 5 of the European Convention for Human Rights, which enshrines the person's right to liberty unless certain criteria are met. It has been interpreted in the UK most recently by the Supreme Court in 2014, the Cheshire West judgment, which set the following threshold for people to be assessed. The person is unable to make a decision about the care they receive or where they live, and is unable to consent to the arrangements in place for their care because of a mental disorder. The person is under continuous supervision and control. The person is not free to leave permanently. Further information can be found in Deprivation of Liberty Safeguards, SCIE 2020. What is staying the same? The Supreme Court decision, Cheshire West DOLS criteria remains. The person who draws on care and support needs to be involved in the process as much as possible and practicable. The requirement to make a best interest decision where a person has been determined as unable to make the relevant decision remains, and the best interest checklist must be followed. It must have been determined that the person is unable to make a decision about their care or residence and unable to consent to their care arrangements for LPS to be used. There will need to be some medical evidence of mental disorder, as defined in the Mental Health Act 1983. There are elements of the Mental Health Act, when in place, that mean that LPS cannot be used, for example where a person is detained under Section 2 or 3 of the Mental Health Act. There remains a requirement to ensure the relevant consultation with relevant people has taken place. A formal written authorization will be needed to enable a person to be lawfully deprived of their liberty for the purpose of providing care or treatment. The person will still be able to challenge the authorization in the Court of Protection Court. An authorization only provides authority for the health or social care provider to deprive the person of their liberty. It does not require them to do so. The person will still have access to someone to support them while they are deprived of their liberty. Was relevant person's representative now to be the appropriate person or independent mental capacity advocate, IMCA? What existing elements of the legislation are being reinforced by LPS? Deprivations of liberty should be authorized in advance, where possible, by the responsible body. This was always the expectation with DOLS, but practice has not fulfilled that requirement. There is a clearer and more explicit requirement to involve the person in the process. The new legislation includes an explicit requirement to consult with others. This was always implied through the link to the MCA best interest process, but it is now laid out more clearly in the LPS.